Hello friends, in this episode today I will discuss some very important case laws on the point of maintenance claim by married women. Nowadays the matrimonial disputes are in the rising graph and every court is flooded with different types of matrimonial cases. Amongst the others, claim for maintenance by the married wife against her husband is one type of case. A married woman can claim maintenance from her husband under different provisions of law. Though the cardinal line for allowance of maintenance are the same in cases of every law. Besides the enactment, there are several case laws which are very much important for every cases in deciding the maintenance for any married woman. Today I will discuss some of these case laws. The first case law is on your screen. In a recent judgment, the Honorable Supreme Court in Sunita versus O'Neill observed that the wife was residing separately and she claimed maintenance from her husband. An objection was raised by the husband that the wife was having sufficient means to maintain herself, which was rejected by the Honorable Apex Court by holding that merely because the wife was earning money and may be highly qualified, but that cannot be a ground to reject claim for maintenance. So, in this case, where the wife claimed for maintenance, the husband took the plea that wife has sufficient means to maintain herself and wife is sufficiently qualified. Here the apex court held that merely because the wife was earning money and may be highly qualified, but that cannot be a ground to reject the claim for maintenance. The next one, it is on your screen. The Chandigarh High Court held that the wife should be in a position to maintain a standard of living which is neither luxurious nor penurious, but what is consistent with the status of the family of the husband. So, in order to decide the quantum of maintenance, it should be kept in mind that the standard of living for which, to maintain which the maintenance is being allowed, that should not be luxurious nor penurious, but what is consistent with the status of the family of the husband. The expression unable to maintain herself does not mean that the wife must be absolutely destitute when she applies for maintenance under section 125 CRPC. This is another important point. The expression unable to maintain herself does not mean that the wife must be absolutely destitute when she files the claim for maintenance. Another landmark judgment by Madhya Pradesh High Court in this matter is Mamta Jaswal versus Rajesh Jaswal, where the Madhya Pradesh High Court observed that where it was held that well-qualified wife is not entitled to remain as an idle and claim maintenance from her husband. Very important observation. Well-qualified wife is not entitled to remain as an idle and claim maintenance from her husband. Another observation, it is on your screen, on the Another observation made by Madhya Pradesh High Court in the same case, Mamta Jaiswal versus Rajesh Jaiswal, that the wife who is well qualified and claiming maintenance by sitting idle is not entitled to get maintenance. So, in this Mamta Jaiswal case, the Honorable Madhya Pradesh High Court clearly observed that well qualified wife is not entitled to maintenance, to sit idle and get maintenance from his husband. Now, the next one from Supreme Court, where Supreme Court observed and laid the law, the burden of proof is on the wife who sought the maintenance from her husband, as she is not able to maintain herself. So, Honorable Supreme Court observed that it is upon the wife, the burden of proof lies on the wife to prove that she is not in a position to maintain herself. The next one, when the petitioner is capable of earning, when the petitioner, that means the wife, is capable of earning and having required qualification, and that when she was working as a doctor prior to marriage, there cannot be any difficulty for her to continue the same profession. Therefore, Section 24 of the Hindu Marriage Act cannot come to the aid of such persons. Section 24 Hindu Marriage Act is for alimony pendenti light. That means alimony during pendency of any matrimonial suit. In this case, the Karnataka High Court clearly stated that where the wife is capable to earn and is in possession of required qualification to earn money, and in this particular case where the wife is a doctor by profession and used to earn prior to her marriage, so there is no scope to think that she is not in a position to earn her livelihood. The next one from Delhi High Court, where the Delhi High Court observed that the appellant wife, who is a qualified chartered accountant and in profession since the year 2003, need not be granted interim maintenance under Section 24 of the Act. In this case, wife who claimed for maintenance alimony pendenti light under Section 24 of the Hindu Marriage Act is by profession, by qualification, she is a chartered accountant. So the question of any allowance under Section 24 of the Hindu Marriage Act doesn't arise at all. So, if the wife is in possession of any required qualification, any professional degree, she is not entitled to get any maintenance. The provision of maintenance is not for the wife to sit idle and get money from her husband. If she has the opportunity to earn, she has the required qualification to earn, and if she used to earn prior to marriage or prior to filing of the case, it is to be assumed that she can earn her livelihood. The next one from Madras High Court, where the Madras High Court held that the grant of maintenance pendenti light, the party should not have sufficient independent income for her or his support. In any case where the husband or the wife, here as we are today discussing the maintenance claim by the married woman, so we can say that the grant of alimony pendenti light, interim maintenance, the party should not have sufficient independent income. Give stress on the word independent income. So, family income of the wife, paternal family income of the wife, if there is any income of the wife from the paternal family business, those may not be taken into consideration. Income should be independent. The party should have sufficient independent income for his or her support. The next one, if a spouse is qualified and has a capacity to earn, then the law does not expect that such a spouse would sit idle. Again, Delhi High Court is using the word, specific word, sit idle. That such a spouse would sit idle and burden the other spouse with maintenance. So, law does not permit the wife who is qualified and is capable to earn to sit idle and to extract money from the other side. This is not permitted in law. This is opposed to the basic cardinal rule of the law of maintenance. The next one, very interesting, from Delhi High Court, where the Delhi High Court observed that if a person is working in Dubai, very interesting, if a person is working in Dubai, he earns in the currency of that country and spends also in that currency. So it is not open to the wife to just convert his income in Indian currency and then seek enhancement. Say a husband is residing in USA and he gets salary in US dollar. Presently, if I am not wrong, $1 is around rupees 75 for the conversion. And if the husband gets a salary of 5,000 US dollar, that amounts to few lakhs if I directly convert it to Indian currency. But it should be kept in mind that when the husband is getting a salary in US currency, US dollar, the husband is spending also in US dollar because he has been staying in US for his bread and butter. He has to pay rent, he has to pay for his transport, he has to pay for his food, everything. And he is paying everything as per the market of US. So it is not permissible to directly convert the quantum of the US currency into Indian currency and to show the court that the husband is earning so much of money. The next one, from Delhi High Court, where the court observed that the courts will have to consider the cost of living as per the living standard in the country where he is employed, and mere earning dollars cannot be the sole criteria to award exorbitant maintenance in favor of the other spouse. What I was telling in the discussion of the earlier case law. Thus, this contention of the appellant does not appeal to this court and he is hereby rejected. Now, the Supreme Court observed that the wife should be in a position to maintain a standard of living which is neither luxurious nor penurious. Again, Supreme Court confirmed these two words, neither luxurious nor penurious, but what is consistent with the status of the family of the husband. The expression unable to maintain herself does not mean that the wife must be absolutely destitute when she applies for the maintenance under section 125. So Supreme Court confirmed the observation of the High Court which I discussed in the earlier part of this episode. Again, Supreme Court observed that when the decree of mutual consent, now I am going to discuss the matter of maintenance from a different angle. Here, the parties filed application for mutual divorce, and after completion of all formalities for the mutual consent divorce, the marriage has been dissolved by a decree of divorce on mutual consent of the parties. Now the wife filed application for maintenance under section 125. What will be the fate of that? Whether the wife is entitled to file claim for maintenance after getting mutual divorce. What is the observation of the Supreme Court? It is here. When the decree of mutual divorce was passed, the same is silent about the maintenance, and after divorce the claim of maintenance by the wife is sustainable. If there is no mention in the mutual divorce about the maintenance of the wife is entitled to file claim for maintenance after passing of the decree of mutual divorce. Another landmark judgment from the Honorable Supreme Court, where the Supreme Court observed that if the wife's personal income is insufficient, she can file a claim for maintenance under section 125 of the CRPC. The test is, note it, the test is if the wife can sustain herself in the manner in which she was accustomed in the absence of her spouse. In the absence of her spouse, not with the aid of her spouse. In the absence of her spouse, the lifestyle to which the wife was accustomed, whether she is able to maintain that lifestyle or not, that is the test. And based on this, the merit of the case will be decided. So, today in this very short episode, I tried to explore the different angles of claim of maintenance by a married wife. If I get positive response from the viewers, I will think to do another episode, further episodes on this point with many other excellent case laws. At the end, I will request you to kindly share this channel, and till then, goodbye. I will be before you with my next video session very soon. Stay blessed. Thank you.